Hello, everyone. My name is Guillermo Perez. I'm a labor educator with the USW Education and Membership Development Department. Just want to encourage folks out there to take some time to check out this webinar that we recently produced on the Families First Coronavirus Response Act. We hope that it's got useful information, especially for those of our members who are still out there working. There'll be more information, more webinars that we'll be producing. So if you can, please take a few minutes to check this out and stay tuned. We'll have more information coming out. We wish you all the best and hope to see you very soon. Hi, everyone. My name is Guillermo Perez. I'm a labor educator with the USW Education and Membership Development Department. I'm joined here by Joan Hill, labor educator and attorney, who works also in the Education and Membership Development Department. Welcome, Joan. And we're here today to talk about two very important leave acts that were recently passed by Congress to try to address the issues and problems that families are confronting, workers are confronting with respect to the pandemic that we're all dealing with currently. And so we're going to take some time to walk through these two leave provisions, do our best to get you good information on what they consist of, who's covered by them, what are the benefits, all of that, with the kind of understanding that this is sort of a moving target. This legislation was passed in a very big hurry. The regulations only recently came out regarding its implementation. So we're going to do our level best to give you the most accurate information we have right now in terms of how these two major leave provisions work. They're both part of what's called the Families First Coronavirus Response Act, but they actually consist of two separate acts. The first one being the Emergency Paid Sick Leave Act, and the second one being the Emergency Family and Medical Leave Expansion Act. And we should say at the outset that there is some concern, a considerable concern, I should say, among people who advocate for workers and workers' rights, that this is being very narrowly interpreted by the Labor Department under the current administration in terms of, what we see as a trend that makes fewer and fewer workers eligible to benefit by this leave. So there's a political element to this. The Secretary of Labor is Eugene Scalia. He is the son of the late, very conservative Supreme Court Justice. And he has a very long history as an attorney, an employer-side attorney, advocating for employers, and especially some of the biggest players, specifically Walmart, in terms of really advocating and devoting his professional life to actually, I would argue, attacking the rights of working people. And now he's in charge of the Department of Labor. So we're not really surprised by the way they are interpreting this. But that said, these are two very important leave provisions. They can make a big difference for folks. And so we want to approach each of these individually to explain how they work. Joan, you have anything to add?
Well, one of the things that we talked about was when we look at and review this information, we always have to think about our members need to check their contracts. They need to consult with their staff and find out if there are other or additional leave provisions that are in play above and beyond these two individual acts. Excuse me. And some of this may have been recently negotiated in your location. So we cannot forget about the opportunities to review our collective bargaining agreement and recent negotiations.
And we should say, as we go through this, you're going to see a lot of similarities between the two acts. The first one we're going to tackle here is called the Emergency Paid Sick Leave Act. And then we're going to follow that up by talking about the Emergency Family and Medical Leave Expansion Act. But to try to make things simpler, when we talk about emergency paid sick leave, we're talking about the Emergency Paid Sick Leave Act. When we talk about expanded FMLA, we are talking about the Emergency Family and Medical Leave Expansion Act, and we'll try to be consistent in how we use those terms. So first of all, with respect to emergency paid sick leave, this creates a new form of protected leave in addition to standard FMLA. We're going to often refer to standard FMLA because it's been a leave provision that's been with us for a number of years. Many of our folks are very familiar with that. And so I think it helps put things in context if every now and again you'll hear us refer to, well, this is similar or unlike standard FMLA. So emergency paid sick leave is a new form of leave, and it is in addition to standard FMLA. It's going to provide paid leave for COVID-19 diagnosis and quarantining for self and others, as well as care for children home due to school and or daycare closures related to COVID-19. It will establish its own set of benefits, eligibility, and coverage standards. So you'll see that it departs significantly from standard FMLA when we get into the benefits, eligibility, and coverage standards. It goes into effect as of today. Today, we're recording this on April 1st, 2020. Today is the first day that it is in effect, and it will sunset December 31st, 2020. So this is just for this year. In fact, both of these acts are only for this year. So what is the purpose of this leave? It's to provide employees who are unable to work or telework protected leave due to, one, an employee being the subject of a quarantine or isolation order related to COVID-19, employee being advised by a healthcare provider to self-quarantine due to concerns related to COVID-19, an employee having symptoms of COVID-19 and seeking medical diagnosis, an employee having to care for an individual who is subject to a quarantine or isolation order or advised by a healthcare provider to self-quarantine due to possible exposure to COVID-19, or an employee having to care for a son or daughter if their school or place of care has been closed or is unavailable due to COVID-19. So we're looking at 5 purposes here for which an employee may take emergency paid sick leave. And Joan, we started off by talking and emphasizing that this is protected leave. Do you want to say a few words about what we mean by that?
Protected leave, we borrow again from the standard FMLA. That means protection against retaliation, including job loss, discipline, or other adverse action or discrimination. It's protected with regard to the employee's right to return or be reinstated to work. So the protections are available that we've seen under standard FMLA. And
we should also say that healthcare provider, right? Back here. Healthcare provider, this HCP, means what it means under standard FMLA, right? That's how it's defined for purposes of emergency paid sick leave, right?
Yes, that is the healthcare provider who would be someone who, under standard FMLA, would certify an employee's need for FMLA based upon their own serious health condition or needed to care for a family member. I would also add under number 1, based upon the recent regulations, I mean, these came out this afternoon, that talked about quarantine or isolation order. And they made it clear in the regulations that this is a broad range of governmental orders, including orders that advise some or all citizens to shelter in place, stay at home, quarantine, or otherwise restrict their mobility.
And with respect to purpose number 2, we also should say that this might also come into play for folks who have an underlying condition that make COVID-19 even a more dangerous possible threat to their health, right?
Yes, they use the term particularly vulnerable to COVID-19, and that would include those individuals with pre-existing conditions or other high risk factors due to exposure. So that is an expansive definition that we were able to gather out of the new regulations.
All right, so let's look at the benefits. So benefits under the Act, it provides up to 80 hours of paid sick leave for full-timers, a reduced number of hours for part-timers based on their average hours over a 2-week period. So let's touch on a little bit about what we're talking about here. So so hours for full-timers means hours the employee would otherwise be normally scheduled to work, again, at their regular rate of pay, but it's going to be up to 80 hours, right, Joan?
That's correct.
So somebody, and then of course there is, for folks who work variable hours, say their schedule varies quite a lot, then the statute does speak to how that determination then is made in terms of what folks are supposed to be receiving, right?
Right. The regulations talk about part-timers being individuals who work less than 40 hours a week. They can average their hours over a 2-week period. They can look back for the past 6 months to see how many hours on average the employee has worked during a week. And if they don't have the information for the past 6 months, it can be based upon the expectation of the employer and the employee when that employee was hired. How many hours am I going to be expected to work?
And then as it indicates here, an employer cannot require the employee to use other paid leave before using this emergency paid sick leave. So that's expressly stated in the law.
Guillermo, can I ask you to go back to the purposes for just a moment, just the previous slide. Reading these regulations, I found it interesting when we talk about the definition of individual, and does that include or require a family relationship? We were afforded a clarification of that definition of individual. There has to be some personal relationship with the individual. It doesn't have to be family, doesn't have to be friend so much. It could be a roommate. It would be someone that, you know, in your life you would be expected to care for them if they were under quarantine or exposed to COVID-19. So I look at this as it doesn't include strangers. On the son and daughter provisions under Purpose 5, again, we turn to the standard definition of son or daughter under FMLA, which is a very broad or expansive definition, including adult children over the age of 18 who are not capable of care. Thank you.
Also, too, anybody who acts in the role of a parent, right?
Yes, that's that like a parent definition, or in loco parentis.
All right, so we spoke about the benefits. Also, finally, in cases of leave to care for a child or other individual, these were purposes 4 and 5 we just touched on. Employees are to be paid at 2/3 their regular rate of pay with a daily cap of $200 and a $2,000 cap aggregate. Otherwise, employees are to be paid their normal rate with a daily cap of $511 and an aggregate of $5,110. And we've indicated here that if an employer permits, an employee may be able to use other paid leave to make up for that 1/3 reduction. So again, if you have other accruals, it may be possible, if you are using this leave for purposes 4 or 5, that you could supplement this amount with your other accruals.
It's important to note here, because this slide uses the language "if the employer permits." The other circumstance where the employer has to permit or agree is if the employee wants to use emergency paid sick leave intermittently.
Right.
to the extent that for specifically related to the child care provisions, to the extent that maybe there is a co-parent or another caretaker that can step in and take care of the child intermittently as well as you. So the employee can take intermittent leave if they're caring for this minor child, if the employer agrees.
All right, and let's now look at eligibility. So this is the most expansive definition. It's a dramatic departure from standard FMLA, which requires folks to have worked for the employer for a year. It requires they have worked 1,250 hours before the leave that they're requesting. In this case, you just have to be on the payroll. There is no length of service or hours worked that are required here for you to be eligible for this leave. So all employees are eligible regardless length of service. Now, employers covered. So all public employers, we're going to talk about some distinctions with respect to federal employees as when we get to the expanded FMLA. But for purposes of emergency paid sick leave, really all public employers with some just very narrow exceptions are covered. And other employers who employ fewer than 500 employees. So it's important to note that the 500 employee threshold does not apply to public employers. Also, employers of healthcare providers or emergency responders may exclude such employees from coverage, and employers with less than 50 employees may claim an exemption with respect to Purpose 5. So, Joan, let's try to tackle each of these. First of all, starting with the 500 employee threshold. It's been a lot of discussion among attorneys, labor side attorneys and employer side attorneys about, well, how do we count employees? And we did get guidance from DOL, right, in terms of how we are to count employees.
Right, and it's a very broad definition of who's an employee. You know, it talks about individuals who are on the payroll, individuals who work within the United States. It includes what we call an integrated employer, so you add together all the various sites, locations, facilities of that employer within the United States. It can include contractors, it can include temporary workers, day laborers, individuals who are already on leave for some other reason are counted. So the DOL's interpretation of this and how you count employees gives most employers the opportunity, at least through ones we deal with under the United Steelworkers and our contracts. Many of our members will be excluded or simply just not covered by this act.
And then we have the situation of healthcare providers, emergency responders, employers, people who employ folks who do that kind of work are able to exclude them from coverage. But it's important to note here, right, that here again, the DOL is defining these terms in an incredibly broad way. So you don't necessarily have to be a direct provider of care or even somebody who actually directly participates in responding to an emergency to be covered, right, Joan, based on what DOL has told us.
Again, it's a very broad definition of healthcare provider. And note, this is not the same definition as a provider who certifies an FMLA or paid leave condition. The definition, if we refer to the Department of Labor, they issued frequently asked questions this past Saturday, and those frequently asked questions, particularly 56, 57, give full explanation of who is a healthcare provider. Essentially, anybody that works in a facility that provides medical services. And emergency responder is also covered under those questions.
Now, with respect to employers with less than 50 employees, right, they too may be able to claim an exemption if the leave that's being taken is for purpose number 5, correct? That is to say, if you're taking leave in order to care for a minor child who's home because of a school closure or loss of daycare. So what's required of an employer in that case to be able to claim an exemption?
Yeah, it seems kind of like a self-determination on the part of the employer. The regulations talk about 3 essential tests that go to establish the whether the employer with less than 50 employees can remain viable if they provide paid sick leave to their employees for this child care or purpose number 5. It involves whether or not there are sufficient other employees to pick up the slack to replace that employee who's off on this type of paid leave. It's not clear how this documentation or exemption is claimed, other than the employer has to make the case that they cannot continue in operations, or they will no longer be a going concern, using one of those accounting principles.
So we can anticipate that we will have employers, right, who are going to try to make use of this, right? Either they're going to perhaps exaggerate the number of employees that they actually have in order to get out from under coverage, or they may also try to reduce their numbers to get under 50 to avoid having to provide this leave. So, Joan, what's your advice to our members out there who are grievers, our local officials who are making sure that our folks get what they're entitled to? What would you tell them?
I would tell them, if you have any reason to doubt your employer's position in either situation, we have more than 500 or we have less than 50. We have to use the tools that we have, which may include the grievance process, include the right to information from the employer. And this is something that staff representatives can have information on, and what type of requests we would ask from the employer to document these numbers. There's a big exclusion for independent contractors, and whether or not an employee is an employee or an independent contractor, oftentimes employers will misclassify employees. So we're going to be concerned about positions that the employer has taken in other situations with other agencies, and decide how to proceed to challenge the employer's position.
And then with respect to notice, what we have with respect to notice right now is that after the first workday or portion thereof of leave, the employer may require employee to follow reasonable notice procedures. So we know in standard FMLA, if your leave is foreseeable, you're expected to provide 30 days notice. With respect to the emergency paid sick leave, this is making very clear that, for the first workday or portion thereof, there's not that similar kind of requirement, but thereafter, you may have to follow some reasonable notice procedures that your employer has established. And this also, I think, Joan, you've already touched on documentation as well. Do you anything more on notice and also with respect to documentation?
We think about notice and the employer's right to know, are you going to show up to work today? And many of our contracts or policies with our represented employers have language that provides for a call-in procedure. I would expect that would be a test of what is reasonable under the circumstances. Regarding documentation, again, based upon these more formalized rules from the Department of Labor, as well as IRS regulations on what the employer can require from the employee to document their need for leave. The
IRS comes into play here because the legislation allows for tax credits, right, for the employer to recoup these costs.
Dollar for dollar, the employer will get a credit against their tax bill for every dollar that they spend paying out these paid sick benefits or the expanded FMLA benefits. So employers are going to be concerned to make sure they have proper documentation under all circumstances for all purposes, including the dates to which leave is being requested, statements from healthcare providers, statements from the employee with regard to their inability to work, and again, quarantine and self-isolation orders. Those kind of documentation can help support the employee's request. They have to request the leave. We don't expect employers to just go around to all the employees and say, here's your leave, here's your leave, here's your paid sick leave. And so the employee will have to make the request and provide reasonable documentation that has been somewhat defined by the Department of Labor and the IRS.
So moving on to enforcement, the Department of Labor has made it very clear that for the first 30 days from enactment, they'll be practicing what they call non-enforcement for employers making a good faith effort. Our recommendation is let's not depend on the Department of Labor to enforce these provisions. We have, I mean, this is the advantage of being a unionized worker. To be a steel worker specifically, it means that we have our own organization, we have our contract, our grievance procedure as a way to enforce our workplace rights, including the right to this leave and the other leave we're about to talk about. So this is to go into effect as of today, April 1st, when we're recording this. Joan, I mean, we want to encourage people. You know, it's really the union and our rank and file activists who are serving as shop stewards, grievers, local presidents. Our folks should take this on and not depend on the Department of Labor to enforce this. Would you agree?
I agree. I mean, even though the regulations suggest, you know, if your employer is denying you these benefits that you believe you're entitled to, you know, 1-800 call Department of Labor. We have a grievance procedure. We have a process to resolve disputes. They also encourage, if you feel like you're being denied a benefit, you should have a conversation. You should work with your employer, communicate with your employer to try to resolve any differences with regard to whether you're entitled to these benefits or any of the other procedures, benefits, purposes, and things like that that are mentioned in the Act. And that can start immediately.
And then finally, covered employers are required to post information regarding this act. Those posters have already been produced in Spanish, I should add also. Folks should be, if you believe your employer falls under that 500 employee threshold, you should be looking to see if those posters are up. And obviously, if you're a public employee, you have every reason to think your employer is going to be covered. And so here again, be looking for those posters. All right, so now let's move on and talk about the other Leave Act that was part of this same legislation. It's called the Emergency Family and Medical Leave Expansion Act. We call it FMLA, expanded FMLA. Unlike the other provision we looked at, this actually amends the standard FMLA. It's been at least for the year that it's going to be in place, not year, up until the end of the year. So what this does, it provides for family leave relating to COVID-19 school and daycare closure. So it's similar to the other leave that we looked at, but it provides for more leave. But it's not additional leave. This is leave that would come out of your standard FMLA allotment of 12 work weeks. Here again, it does establish its own set of benefits, eligibility, and coverage standards. And here again, it has now gone into effect as of today, April 1st, and it too will sunset on December 31st. So the purpose of the leave is to provide employees unable to work or telework protected leave to care for a child under 18 years of age if the school or place of care has been closed, the child care provider is unavailable due to a public health emergency, which can only mean one thing: an emergency with respect to COVID-19 that's been declared by a federal, state, or local authority. It will provide up to 12 weeks of leave, but the first 10 days or 2 weeks are unpaid leave, while leave beyond that point is to be paid at no less than 2/3 regular rate of pay with a daily cap of $200 and a $10,000 aggregate. Eligible employees may use the emergency paid sick leave for the first 2 weeks, or elect to use accrued paid leave for the first 10 days. And here again, if an employer permits, an employee may be able to use other paid leave to make up for that one-third reduction. So this is where these two acts sort of overlap. It is possible for somebody to be able to use the emergency paid sick leave to cover the first 2 weeks of this. Because the first 2 weeks are unpaid, that would allow them to get some pay for those first 2 weeks. It would be, again, 2/3 their regular rate. However, keep in mind, this expanded FMLA is part of your FMLA allotment. So unlike emergency paid sick leave. So if you end up doing this, it is going to run concurrent. So that means that will eat up, even though you're using emergency paid sick leave, that's still going to count towards your standard FMLA allotment. I hope that makes sense to folks.
It does make sense, Guillermo, because what we have to look at is, again, we defer to a lot of the standard FMLA language, which allows the employer to run paid sick leave concurrently with FMLA. The unique thing about this is we've seen is if the employee takes their 2 weeks of emergency paid sick, and then they take the first 2 weeks of expanded FMLA for this one purpose, unpaid, but use accruals, other paid time off that's provided for under their collective bargaining agreement, then they take 10 more weeks of this expanded FMLA. Ultimately, they've got 14 weeks, but they've had to burn 2 weeks of their paid time off.
So people just need to keep in mind, when we talked about the emergency paid sick leave, that is additional leave. So whatever FMLA you've used in the past, it doesn't matter, that leave would still be available to you. When we talk about this expanded FMLA, then yes, it will depend. If you've used some of your FMLA leave time, then there's going to be that much less available to you to use this emergency leave. And you may want to be careful to hold on to that emergency paid sick leave, right? You may decide, you know what, I don't want to use up those 2 weeks. I want to hold that in reserve in case I really need it for some of the other reasons that were provided for in that paid leave. So this gives people some flexibility in terms of how they want to apply this.
And because this also allows the employer to permit using your accruals to make up the 1/3 difference, we see the same language as we saw under paid sick leave, that the employer also can permit you to use this expanded FMLA intermittently to the extent that it's agreed upon between you and your employer.
And then with respect to eligibility, here again, it's different. It's obviously different from standard FMLA, but it's also even different from the emergency paid sick leave, because here you have to have been employed with the employer for at least 30 calendar days immediately prior to the leave that you're taking. Now, who's covered? All non-federal employers, so those folks who are employees of the federal government, there's a very good chance that this is not going to be available to you, but you really have to check with your staff rep to confirm that. Otherwise, if you're a public employee, this will be available to you regardless of how many folks are employed by your employer. If you are a private sector employee, however, we're back to this 500 employee threshold. Again, everything that we talked about in terms of how employers count employees applies here. And similarly, employers of healthcare providers or emergency responders may be exempt. Here again, this is a very expansive definition of what a healthcare provider is or a responder. So we can anticipate a lot of folks who work for healthcare providers are likely to be exempt. And we also have this fewer than 50 employees as a possible exclusion as well, right, Joan? And again, these exclusions operate just in the same way we discussed them with respect to emergency paid sick leave, right?
Right. Same test, same viability question.
So finally, notice to the employer. Here, notice to the employer is to be as soon as practicable. And again, with respect to enforcement, same exact language. The DOL is going to take this non-enforcement approach for the first 30 days from enactment. But again, we would encourage our activists to use your grievance procedure if you have some reason to believe that that your employer is violating this. That is to say, if they're claiming that they have more than 500 employees, then you question that. If they're claiming they have less than 50, that would allow them to get out of this entirely. Here again, we would say use the grievance procedure. Joan, what would you add to that?
I mean, I would add that there's a poster that employers are required to place in the facilities where employees are regularly have access to. I also think that the question of this lax enforcement, it's interesting and or important to point out that 30 days is from enactment. So beginning April 18th, the Department of Labor will be enforcing this. But again, we can still utilize our own dispute resolution process, which is our grievance process. And sometimes an informal discussion can resolve any questions about coverage and employees' eligibility and purpose qualifying situation.
All right, so I hope folks got some good information out of this presentation. As we said at the outset, this is evolving. So we will continue to try to give people up-to-date information on what's happening with these particular leave provisions, especially how they're being implemented. But we do hope this has been useful. We want to wish everybody the best out there right now. It's a terrible, terrible time with this pandemic. But the union is here, we are working, and I know a lot of our folks are working, and we want to make sure we're doing everything so that we get through this and we come out stronger. Joan, would you want to add anything else?
Yeah, I just, this is something that Guillermo and I and our team have been working on really since the enactment of the law, and trying to dissect this, research this, review as much information, and share information with other lawyers and those representing union members and workers across the country. The details of this keep unfolding. I thought after we were talking about this, about the son and daughter and the care, well, there's a special rule for children ages 15 to 17.
Oh, that's right.
And so, we're going to make sure that staff have the most up-to-date information as it comes to the enforcement of this and the administration by the employer. Stay tuned. We'll keep you informed. You are emergency responders for us, and we try to make sure that we get the most important information and relevant and up-to-date information to you. Stay strong, folks, and say something good about your union.
Take care, everyone.